got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask your
I have
questions
an objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. That should at least be noted for the record.
It was
I wouldn't be able to do that.
Your objection's noted. It's overruled. Go ahead, Attorney Opera.
So that needs to stop happening.
In
It needs
addition
be
to
fair.
the hat,
All right, I'm going to excuse the jury.
All right, for the jury.
Can't keep doing stuff without. It should be a fair trial. That's my right. You shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being called
documents
that
are
name.
being put on the
I don't consent to
witness
being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did
attempting-
it get there?
Sir, do not
I'm not
interrupt
enti-
me, or
I'm-
you will
I'm not
forfeit your
entitled
right
to
to be
know how I got
present
there?
in this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm going to make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're going to clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit anything.
I'm going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody, and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy, or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05, there was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35, at 3:06, there was the hilarious comment, at 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. Again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses. Okay?
And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to do.
I'm bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately.
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being able.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be quiet?
I'm advising you to be respectful when the jury comes out.
Are you telling me to be quiet, or are you asking me?
I'm asking you and advising you.
Okay. Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
we're all adults in here. I've never told you to do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not going to work. I'm supposed to be scared of getting removed or something.
Thank you, everyone. Please be seated. Statement continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we have 117. Madam Clerk, would you please turn the display back on?